Hi, welcome everybody. We're just waiting just a moment for everybody to get on. Okay, hi everybody. We're just waiting a minute for everybody to join, but I'm going to go ahead and say hello and introduce our panelists today. First, I'm Stephanie Trevino with Lone Star Justice Alliance with the Survivors Project, and this is Elizabeth Henneke with LSJA. She's the Executive Director. We have Rochelle Cahan with Collective Liberty and Gina Lungwitz with the University of Texas School of Law Domestic Violence Clinic. So welcome everybody, and we will go ahead and get started.
Hi, welcome everybody. As Stephanie mentioned, my name is Elizabeth Henneke, and I am the Executive Director of the Lone Star Justice Alliance. And we launched 3 years ago with the intent of improving the lives of youth and young adults in the justice system. And one of the things that we started with was reviewing about 770 cases of youth who had been put into the adult system, and discovered that about 10% of those kids under the age of 18 were there for crimes associated with their own victimization as survivors of trafficking and as human trafficking and domestic violence. That statistic shocked us. Despite national statistics, we were still surprised at the number of children who are incarcerated for the crimes of their abusers. And we set out with the strong support of Elizabeth Ross Hadley at Greenberg Traurig to change that. And from that effort came the Survivors Project. So we're going to tell you a little bit about that history today, and then we'll launch into more of the technical aspects of engaging in representing survivors. So thank you so much for joining us. We're really excited. I'm going to launch the PowerPoint now and give you guys something to look at besides my face. All right, here we go. So hopefully you're in the right place. This is our CLE of ethical issues and representing survivors of human trafficking and domestic violence. We launched the CLE with the hopes that each one of you, I think we now have 88 of you, will all decide that representing survivors of domestic violence and human trafficking who've been convicted of the crimes of their abusers is a great way to do good. And you'll join us in this effort by agreeing to participate as pro bono attorneys. So that is the intent today, but you will get free CLE credit either way. Our agenda today is to give you some background on the project and some introductions of our team. We want to define human trafficking and domestic violence and make sure everyone understands the contours of that. We'll give you some information about how to put together an application for clemency for those survivors, and then we'll talk about creating reentry plans for those who are assigned incarcerated clients. So first, let's just frame the conversation. So I mentioned that LSJA and Greenberg Traurig together partnered on bringing to light the issue of children who have been incarcerated for the crimes of their abusers. And with Zamfronia Thompson and Judith Zaffarini, there was legislation to create a panel that would provide expert guidance on clemency applications to the Texas Board of Pardons and Paroles, so that those whose convictions seemed unjust for this nexus between their survivorship and their crime could actually have an opportunity to have their convictions pardoned or commuted, and they would not have the collateral consequences of those crimes. Unfortunately, that action, while it passed unanimously through both the House, or passed through both the House and Senate, it ended up getting vetoed. But we were very excited when the governor came forward and actually established a specialized clemency application for survivors of human trafficking on February 20th, 2020. This showed real, true leadership on behalf of Governor Abbott's staff and on behalf of Chairman David Gutierrez, who I believe has such a heart for survivors who have been victims of these horrific crimes. I think it's important to use the governor's own language because it is such a wonderful representation of what this project is about. So I'm going to actually read it to you. I know that's obnoxious, but I hope you'll give me some grace here, which is, they say that Texas is committed to empowering the survivors of domestic violence and human trafficking. And one of the surest signals of that goal is laying out a true path to redemption and restoration, said Governor Abbott. The gubernatorial pardon plays an important role in this redemption process because it offers a second chance to survivors with criminal convictions resulting from their abuse or exploitation. I'm grateful for our ongoing partnership with the Texas Board of Pardons and Paroles as we work together to develop a stronger justice system that promotes redemption, restoration, and transformation. I can't tell you or begin to emphasize to you what a momentous moment this has been for survivors of domestic violence and human trafficking, both in the state of Texas and nationally. It is the first time that a state has been this bold to recognize the nexus between victimization. And we are just so proud to live in a state that recognizes this important issue. Once the governor created this application, it became clear that we needed to provide pro bono support services to those who would be applying for clemency. This was such a critical aspect of the work because we wanted to make sure that applicants who applied for this gubernatorial process had true support. So we've come together as the Survivors Project. I want to throw out that if you are part of an organization who is not listed here and you'd like to formally join the Survivors Project, please reach out to me or to Stephanie Trevino. But these are the incredible partners that we have, and they reflect a real diversity of viewpoints on this issue, and we're thrilled to be able to partner with each of them. So let's just step back and say, what is clemency? So clemency is a mechanism for granting a person convicted of a criminal offense relief from a court-ordered sentence or some form of punitive measure, a fine, for instance. There are two main methods for granting clemency, which is either a pardon or commutation. It's critical to understand the difference between them and what is available under this application, because your clients may not understand. You'll notice this picture is of a pretty infamous case, Santoya Brown. And Santoya was a juvenile who was convicted of killing her sex trafficker. She was recently pardoned in Tennessee and has been an advisor on the project, which we're really grateful for. So understanding the difference between pardons and commutation. So a pardon is the use of the executive power to completely forgive the offense that the person was convicted of. It removes all penalties and punishment and all collateral consequences. So if someone was convicted of felony drug trafficking, right? So imagine a scenario in which a young woman was convicted of drug trafficking that she was required to be doing at the behest of her sex trafficker. If someone has the power over you to sell your body, they're going to have the same power over you to get you to sell drugs. And a pardon would relieve any punishment that is still happening from that felony conviction. And it would also remove the collateral consequences, which could be, for instance, being unable to apply for a job without a felony conviction, which can impact your ability to enter a positive workforce. It can actually impact your ability to receive housing or public benefits. for our population of children, it can really impact their ability to go to college or to receive financial aid. So the collateral consequences being removed is an critical component of people being able to move on from the victimization that they may have suffered. So pardon is a complete forgiveness. A commutation is different because it's the use of a power of the governor to reduce the sentence from a criminal conviction. So your ultimate conviction will remain the same, and therefore the collateral consequences that attach to those convictions are still there. We're happy to report that the governor and the Texas Pardons and Paroles have created an application that is for a full pardon. So those who are able to receive and move forward on this application will have all of their collateral consequences removed. They'll be able to return to receiving benefits for higher education. They'll be able to take out student loans. They won't be blocked from certain jobs and opportunities. And the scarlet letter that attaches to their past will be removed. We're very excited about that option. So I mentioned that there was a special application created. So this is from the Texas Board of Pardons and Paroles website. So unlike traditional commutation or pardon applications, the Board of Pardons and Paroles has created a specific focus of the application. And over the next 2 trainings, you're going to be hearing from experts from around the state about how to prepare these applications, what you need to include in them, what some of the tricky legal issues will be. And so this is what you're aiming for, is to apply to this process so that you can get your clients the ability to actually receive clemency in the form of a pardon. That's what's available. So I mentioned that this is all with the hopes that you'll take pro bono cases. So let me tell you how this is going to work. If you entertain and enjoy this CLE training and you think to yourself, wow, this is how I want to spend my time, is getting children, young adults, or adults from receiving and being constantly reminded of their own sex trafficking and domestic violence. I want to give them a path to redemption and grace and rehabilitation. And you think to yourself, that's a great way to spend my time, then please go to the Lone Star Justice Alliance's website, which we will post at the end of this presentation. And there's a process by which you can submit your information indicating that you would like to take cases. You'll also see on that website that we have been soliciting from survivors themselves, also an intake process. So we're both intaking pro bono attorneys and we're intaking from survivors. And so we have a group of law students, largely from the University of Texas School of Law, thank you so much to their support, who are going through and pairing individual pro bono attorneys with survivors so that we can pair you based upon your needs and your understanding. One of the biggest questions we get is, how many hours would you expect this case to take? So I'm going to give you my best guess, with the caveat that this has never happened in the country. This is the first time that this process has been available. But in my experience, I would expect that if you sign up to take a simple misdemeanor case, so someone who has a misdemeanor, you can expect that from start to finish, your case will take no more than 60 to 80 hours. And we know that that's quite a lot. It could be substantially less, but I want to give you the absolute outside. And the majority of that time will be conducting investigations for your clients, and it'll be investigating how their cases are going. For those who are really committed to this work and want to make transformational change, who sign up for felonies, we think those could take up to 100 hours because you're going to be providing expert level guidance from experts that we've identified who can do psychological exams and social histories. So we've been lucky enough that several experts from around the country are willing to provide pro bono their services for this project. And so we'll be pairing those who take felony cases with that effort, unless it's a simple felony. But trust me, we'll guide you through it. Once we pair you, you'll sign a participant agreement. Gina will go through that more. And then we will assign you a case. LSJA is here to help you the entire way. So we have several people who have been doing this work for years. I was formerly a professor at USC Law School in California and did a similar work with domestic violence. It wasn't a pardon, but it was a relief application, and we will make sure to guide you through that process and be available for questions the entire way through. So trust me, today is not the last time you'll hear from us. We want to make sure that you feel supported. So with that sort of brief overview, there's a lot of detail to get into over the next 2 trainings, but with that brief overview, I'm going to turn it over to Rochelle Cahan from Collective Liberty, who has been just a wonderful partner for us and importantly brings a unique perspective on this work. So thank you, Rochelle, for joining us, and I appreciate you all and look forward to speaking with each of you who decides to do this work and do good with your community.
Awesome. Thank you so much for that. Hi, everyone. I'm excited to chat with you, and I want to flag if any of you are connected to or work with prosecutors' offices, they can also be strong partners. So that's a valuable connection to have for this. So what I'm going to chat about is how victims end up criminalized. And a lot of what I will draw on is from my direct experience prosecuting. I was a prosecutor in Philadelphia for about 6 years, and I handled over 20,000 cases, anywhere from charging through to jury trial and sentencing. And the majority of what I handled was domestic violence. So as you probably know, after you handle 5, 10, 15,000 of something, you start to know sort of exactly what the patterns are. There's like 6 to 8 types of behavior you might expect. And in that process is when I started noticing the anomalies, and that's how I found trafficking. I became a prosecutor the same year human trafficking became illegal in the state of Pennsylvania. Needless to say, we had no case law, no investigative best practices, and no processes to fall back on, and we were figuring it out as we went along. So it was a lot of our gut instinct, and this came through as a case where maybe her boyfriend beat her up over money, but if you dug a little deeper, it was actually the pimp penalizing her for not bringing in the specific amount of money he told her to, for example. So that's how I think a lot of our trafficking case identifications happened. And I'm sharing that to say that a lot of these prosecutions, when we might not, as the criminal justice professionals, identify the victim, it's because that's the context we've been working in for the past basically decade. We're just now starting to figure out the best ways forward. So I'm going to take us on a little bit of a history lesson to walk through why that might be. And luckily, if everyone here is lawyers, we know that we're working in a common law system. So even if a law passes, it can take decades before we really settle on and establish how it's going to be enforced, what's going to make it through appeals, who's going to push the envelope where to adjust the definitions. And it's not just as simple as passing a law. So going into some of the history, women over the past couple of decades have dramatically increased in the number of prison population that they're occupying. And a lot of that does overlap with victimization, whether it's victimization in terms of self-defense or sort of like historic poly-victimization type things where they just have multiple experiences compounding that might have led to them being in that position. I'm sharing this infographic to show that quite a few of these crimes are the crimes that trafficking victims get arrested for. And so it's really worth noting that if we're not doing really clear intake at the criminal justice level to identify context around why and how they ended up in certain situations, we could entirely miss that this was forced behavior, for example. And it's not really built into the criminal justice process to try to determine if there's a really complicated and long backstory of abuse that led to this situation. It's sort of black and white, like, did you commit a crime? Okay, you're going to jail. So there's been a lot of studies that really outline how that has increased the prison populations dramatically, specifically for women prisoners. One incredible statistic that the government released is that 75% of women in prison have histories of sexual assault and intimate partner abuse through to adulthood. So I'll walk through a few case studies that show that a lot of those experiences are also the direct correlations to why they're in prison. And at best, we're minimizing their sentence, but we're not giving them full access to the affirmative defenses that they should be able to access, or straight up not guilty or no charge decisions that could and should be made quite often. So I'm going to start with domestic violence, but I want you to keep in mind throughout that it does have direct impact on sex trafficking implications, not necessarily on labor trafficking, but definitely on sex trafficking. So it's kind of important to understand how culture and the general experience we have when we react to domestic violence to show why the criminal justice system is sort of mirroring that. It essentially has been legal. Quite a few of the domestic violence behaviors have been legal and not necessarily criminally enforced. And that dates all the way back to before we were a formal country that had, set national laws that can trickle down to state enforcement, et cetera. And a lot of what that means is it was more informal and community-based responses, which in a lot of ways is what people are pushing for us to go back to now, because that criminalization has increased so much. And I think it's important to know that when the Violence Against Women Act passed, it was creating criminal structures around state interventions into domestic violence. And it wasn't until the 60s where we started to have more policies that gave the people that were being abused in the home options for remedy and relief and the ability to sort of leave that situation with state support. But as that policy has continued to develop over the next 60 or so years, you can see how the common law interpretations are shifting the approach. And that is in part what's led to the increased criminalization of victims. So it wasn't until almost 20 years after these laws started being enforced and criminal penalties started impacting the interventions that states made in domestic violence situations. It took almost 20 years before the women acting in self-defense were held to a different standard, not a man in that situation necessarily, but a battered spouse being given the reasonable standard within the framework that someone in that psychological experience might be having. So a lot of what I'm going to talk to you about is very gendered, and that's not because I look at it that way. That's like, we're still very failing at looking at male abuse victims and gender nonconforming. So a lot of what I'm just parroting back the language in the laws, but I promise you I'm not excluding. But that goes to show that it took until 1977 for the reasonable woman standard, and we haven't even developed if, for example, in trans and gender nonconforming relationships, what it might look like, and also what a heterosexual man might be experiencing because of toxic masculinity and his inability to report the experience. That's not included, and we still don't have enough policy and process around that. So those victims are even less likely to be identified. And also what's worth noting is we didn't even have battered women's or rape crisis shelters until the 70s at all. So there weren't really resources to have that kind of support. It's been improving, and we now have thousands of support services across the country and support resources across the country. And that was an identification that we do need community wraparound, more holistic support in these situations. And also, it hasn't necessarily caught up everywhere. The way the criminal justice response adapted was in the 80s to really go hard on the criminalization of this behavior, working towards the passage of the Violence Against Women Act in the 90s that really funded criminal justice responses to domestic violence. That's what then led to prosecutorial policies where they couldn't drop the case, and it was made clear to the victim that they didn't have the ability or the right to choose to drop the case, that it became a case that was a matter of the state keeping the state safe. I can't tell you how many times I had that conversation, that I represented the Commonwealth, not the victim, and found ways to work around and through and with that, but that was what we were taught and how we were taught to push. And so the collaboration with social service agencies and bringing them into the process to make sure that the victims' needs and rights were also built in was really important. It was around that same time that people started advocating for clemency around the self-defense charges, and women, or it's in that time period, it was only women, honestly, that were getting this type of support, but that their self-defense mattered and should be something that prevented them from also having to serve jail time. So one thing that I experienced, I was the special domestic violence prosecutor, and for almost 2 years, I exclusively handled the protection from abuse order courtroom. And that's like a piece of paper that's supposed to keep you safe. And that was in criminal court. So it started out as a civil order, but then it carried with it criminal penalties. And a lot of national policies trying to shift the way we handle domestic violence to not just dismiss it and not just minimize it, which is why there was the no drop policy. Like, we're going to take this seriously, we're not going to minimize it. They also started passing policies requiring arrest to diffuse the situation. And those were attempts to enforce and create a situation where the abuser felt like there were consequences and the person who was being abused felt like there was reprieve and potential help. But what it did have backlash, and it did backfire in a lot of ways. So, for example, in those required arrest situations, if the person who was being abused got in a good swipe and maybe scratched their face and caused bleeding, and that was the only visible injury, maybe the person who is being abused ends up getting arrested instead of the abuser. Or maybe they both end up getting arrested because by the time the police show up, they're both fighting and it's unclear who instigated. And of course, the abuser's not like running around admitting that they instigated it. So then that's how the women started getting arrested and criminalized. Often when I had male victims, it was, first of all, very rare that I had them, and it was only in instances of extreme violence where it was indisputed that they were the ones that were sort of just standing there and getting abused without giving it back. And there's also an extreme standard where if male victims act in self-defense, it's never believed. It's always looked at as they're the ones that were probably starting it and she acted in self-defense. So it gets really convoluted and difficult to suss out and identify the truth. And I saw this the most in the protection from abuse order cases, which is why I started there, is that it was so hard to get protection from abuse orders that public policy shifted to make it easier and lifted some of the barriers. But then what started happening is retaliatory protection from abuse orders, and essentially it nullified them. So if the person being abused got a protection order, the batterer would then go get one and allege that they were in fear of their life. And since so many of the barriers had been lifted, they did get them. And so often I was handling cross petitions, and it did become very difficult to enforce. And it also is a form of continuing the abuse and control because they're taking them to court all the time for supposedly violating the order. So domestic violence gets very messy and very difficult, and the criminal and civil processes are a way that the abusers continue access to their victims and abuse. They use the system itself. So it does get very difficult. So why all of that matters is I think people get too overwhelmed to really sit down and sift through the facts and figure out what's really happening. And what that means is we've sort of come full circle and we're a little bit too inactive again. And so what ends up happening is people are still being killed at the hands of domestic abuse. And 85% of those cases, the person who was killed called the police for help at least one time. And so the intervention didn't work. Also, in 50%, they called at least 5 times and the intervention didn't work. And you'll see it in the news every quarter, at least once every quarter, national news of a person who called for help many times and still ended up killed at the hands of their abuser. So the solution's not working, and it's leading to criminalization of the women, to the point where the majority of women in prison for killing someone was abused by that person. In the states that collect that statistic specifically, it's 2/3 or 93%. And there's been estimates and extrapolations by academics that overall it's 90%. That's not hard data, but the California and New York data is hard data. And again, you hear me saying women. We're still only looking at women victims of male perpetrators in any real concrete way, which is a huge way that the others are getting left behind, and we're not even talking about clemency for them quite often. So I'm not going to get way too deep into the process because I definitely need to share the time with other people. But it's important to note that in the center of all of these investigations and the cases that are coming across your desk, if you support us through this clemency process, is people were trying to sift through the facts and find the truth. And that doesn't mean they did accurately. And so it also doesn't mean, if we're looking at some cases that are going to be old, right? So it doesn't mean that they even had the knowledge or the policy to support those decisions. So looking at them with a fresh eye to really help advocate for your client in these cases is going to be really important. And keep in mind some of the reasons why the person who was abused and maybe did retaliate isn't going to share the full story, because it comes back to custody access of their children if they have shared children. It comes back to shared assets. And there's a lot of potential consequences that they can experience in just life in general and day to day that might be a disincentive. So the few things that I saw the most often get overlooked are when it was self-defense, which is the most obvious, but also immigration considerations, not only for themselves, but the abuser. They might want to be away from the abuser, but they don't necessarily want them to be deported, for example. Also, sometimes the abuser is their only source of income. There's the ways that I saw the most often and the most distressing in the specifically protection from abuse courtrooms were if the abused person tried to leave the situation and take their children out of the situation, the abuser often charged them with kidnapping and reported that their child had been kidnapped. And it created not only felony level criminal charges they had to face, but also the potential to permanently lose access to their children. And the flip side of that, if they don't protect their child or they leave and don't take their child with them, they can be charged with failing to protect their child or child endangerment or child abuse. So it's a lose-lose situation that if the abuser is a controlling and manipulative abuser, can use criminal process to criminalize them without them facing any penalties or consequences. And then this is going to apply a lot in the human trafficking cases, but it's also true that in domestic violence situations, there's a lot of coercion and a lot of acting out of sort of just self-preservation that can lead to the abuser forcing the victims to engage in criminal activity that then the victim's the only one experiencing it. This also shows just how polyvictimization leads to people not self-identifying and not announcing like, hi, I need help, that it doesn't feel like they can get help. And so they're not always asking for it. And especially if they end up criminalized or arrested, or someone that they know ends up criminalized or arrested, it's going to be a strong disincentive. So a few high profile cases that I'll go through quickly that people might have heard of, just to show that this is happening everywhere and not just in specific political or regional areas. Marissa Alexander had been in a long-term abusive relationship, and in the context of an actively violent situation, she fired a warning shot. It didn't cause any property damage. It didn't hurt anyone. And she was sentenced to the mandatory minimum of 20 years in prison for firing a warning shot to try to keep herself alive. She appealed, so luckily it wasn't something that stood, but that had a lot of public outrage and uproar. Similarly, in New York, Nicole Adamondo was sentenced to 19 years to life because she killed her abuser. He had been like horrifically, brutally beating and raping her for several years. And just that day, he had physically assaulted her. And once he fell asleep, she shot and killed him. So they said, you could have left instead of killed him because he was sleeping. You should have known better. And it completely ignored the way trauma plays into this decision-making and how that's still acts of self-defense. And in homicide cases, that can still be self-defense, but for some reason, once it comes into domestic violence, they call it into question. So that's how her life has ended. And this case in Philadelphia, she was actually found not guilty. A really high-powered defense attorney pro bono took her case and fought really hard because she shot and killed him in an active domestic violence situation. And what I like to know about this case is he's been grooming her since she was 13 when he was like, quote unquote, dating her as a 19-year-old. And it, like her entire adolescent and adult life was shaped by his abuse. So that was really compelling. And I think makes it easier to convince a jury, whereas the other ones, it was less. I mean, when it's a child, it tends to be a little bit more empathetic and sympathetic brought into it. So I think I'm maybe going a little too slow. So I have so much to say about all of this, and I'm so passionate about all of this that I could probably talk for hours. So I'm sure we'll have follow-up, and I'm happy to chat with anyone about a lot of the specifics. But this goes back to the consequences that they'll experience if they don't report the abuse or if they act in attempts to help themselves. It's not just when they act in self-defense, but even if they flee without enacting violence, they can still be criminalized and still often are criminalized. With human trafficking, it becomes also very tenuous, and the relationship begins with manipulation and coercive control almost every single time. So it's important to note that their free will and autonomy is the first thing that traffickers try to take. So for us to then say they were actively, autonomously, empoweredly making these decisions for the criminal activity, but not for the trafficking activity is such a huge mental disconnect that it shouldn't stand. For those of you who don't know what human trafficking is, I'm just going to briefly go through it. It's not like the movie Taken. It's not just when someone is an immigrant, like smuggled across the border and forced into labor. It's not when a teenager is like kidnapped at IKEA. That's like maybe 1% of trafficking, probably less than that. Most of it is the coercion, the manipulation, and the gradual abuse. It's a lot of emotional coercion and defrauding and manipulating. And then what comes next tends to be the force and the violence once they've really broken someone down and mastered the emotional and mental control of things. So what's helpful to think through when you're thinking of human trafficking, the definition, of course, we need to meet the statutory definition. But when you're looking for the behavior, looking for the action, the means, and the purpose. So what action did the trafficker take? For example, moving a victim, recruiting a victim, advertising a victim online, giving them a job, but then not paying them. What means did they use to achieve that action? For example, force, fraud, or coercion. And what was the purpose of it for either forced sex or forced labor? So if you look for those three things when you're analyzing these cases to help advocate that it was in fact part of a trafficking instance, those will be the helpful pieces of information to empower that advocacy. So this one is a lot less detailed of a timeline because it's a lot newer area of law, but we like to credit the 2000 Trafficking Victims Act, the Trafficking Victims Protection Act, sorry, as the first federal law. But decades before that, these laws were being prosecuted under a number of different federal laws, even weirdly, grossly titled White Slave Traffic Act, that's now the Mann Act. And you'll see that we have still only like 800 federal prosecutions each year for trafficking, but there's still quite a few prosecutions for these laws. So they're still prosecuting the laws that they're comfortable with, that they have policies and strategies for, and it's still a really emerging and under prosecuted law when it comes to human trafficking specifically. So when you're looking at the different types of behavior and crimes, these are also worth looking at to show that trafficking was in fact part of the behavior. What's really important about when the TVPA passed is that it brought everything together. And as I mentioned, it didn't really empower additional federal prosecutions for trafficking, but by bringing all of those federal statutes under one, it empowered and really pushed the states to start developing their own state level legal structures, criminal statutes, processes and procedures, and case law. And that has been a big boon for the number of not only trafficking cases that have happened across our country, but also improving the laws that we have in all of our states that are potentially further victimizing and also not stopping traffickers. So we still are developing all of those laws. As you can see, this is a new law that we're all talking about here today to support the people who were trafficked and also criminalized for behavior related to that trafficking. Those laws are still passing across the country. We're improving the different civil remedies and legislations around business regulations and trying to close loopholes for exploitation in businesses, but that's still emerging and a slow, long bureaucratic process that we're in the middle of now. So this effort in Texas really can set the stage and example for the whole country if we do it right. And part of the reason we have so many victims being criminalized is that process is slow. And part of sort of the advocacy around improving the law is the failures and the data and the examples of how the law is failing the people we're trying to protect. So regrettably, it's this double-edged sword. So one thing to note also, the domestic violence and human trafficking nexus is domestic violence, it creates the same vulnerabilities that traffickers prey on and is often why in cases that it might come through to the criminal justice system as a domestic violence case when it's actually human trafficking, because most people don't know what that blurry gray area can be. And also, it's not always clear that the person being trafficked is aware that, for example, money is being exchanged. They might just view it as rape. So there's a lot that needs to be done at the attorney's level of looking into the holistic experience. And even if you're talking to people that are experiencing domestic violence, paying attention to whether or not that did lead to trafficking. And even if not, the statistics that we talked about at the beginning of this section really shows that it's a continuum of vulnerabilities. So if a person is finally able to leave the domestic violence situation, but for example, had to leave everything behind, they might be unhoused. And that's one of the favorite vulnerabilities that traffickers prey on. But also domestic violence tends to, it's like the abuser's favorite thing and most necessary thing to maintain control is keeping them completely isolated from any sort of support or community. And that's another massive vulnerability that traffickers exploit. It makes it a lot easier to control. So traffickers and domestic abusers are very much the same when it comes to their mens rea, their mentality, their methods of operation, and what they do to maintain control of the situation. So they're going to look very similar when you're paying attention to the behavior of the perpetrator themselves. So what leads to the criminalization of trafficking victims specifically is the fact, as I mentioned before, that our laws are still majorly catching up. For example, in most US at the statewide level, the states, the approach to enforcing the law is very much maximized to obtain prostitution arrests and prosecutions. That's what the statistics are emphasizing. That's what part of, like, we have a vice department, and that's one of the 5 crimes that they're supposed to prosecute. So it's very much empowered and rewarded to have these arrests. And what that's doing is disincentivizing them from making sure that these aren't potential victims. And so what we always advocate is just, we need to stop enforcing this crime, honestly, because the margin of error is way too high. And I think quite a few of the vacatur and clemency applications are for prostitution-related offenses when it was forced behavior by traffickers. And in some states, Hawaii actually recently passed that just de facto, if you have a prostitution arrest, you can get it vacated. They're just de facto allowing that now because they've recognized that it's overly criminalizing potential victims. Another thing, it's a major impact on deportation. There's specific crimes that are just automatically deportable, and prostitution is one of them. It's called a crime of moral turpitude. So that's a really strong mechanism for control with traffickers if their victims are undocumented, because it's not just, oh, you're going to get arrested and bailed out immediately and it doesn't matter. It's you're going to get arrested and deported and basically never allowed back in because you have this on your record. So when we criminalize the victims, it really empowers the abuse and control from traffickers. So the common charges that you'll see, that at least that I've seen, is, of course, the prostitution and human trafficking related charges. You'll often see some victims arrested for the charge of human trafficking because if there's a minor in the network, the bottom or the other adult victims in the network get arrested with the pimp. Sometimes instead of the pimp, because the pimp, they're protecting the pimp or he has kept himself pretty much disconnected from it. This is also true that tax evasion, money laundering, and similar financial crimes, the trafficker will use his victims' social security numbers and identities because he is not creating a paper trail, he or she. They're not creating a paper trail for themselves, and they don't care about their victims. So if that's where the paper trail can be, and they can be as removed as possible from any of the potential evidence, that's what they're going to do. And there's a number of survivors that we've worked with that talk about spending a decade or more in jail for financial related crimes that they took because of their trafficker. And they had no real defense because it was in their name. They're on the surveillance footage going to and from the bank. And no one was caring or paying attention to the fact that they were being forced to do it. And it's a completely different department that typically handles financial crimes. They're not typically involved with special victims types cases. So they're not always catching what they should be catching. And most of my cases where the victim was a juvenile, we found them because I had good relationships with a public defender, and they would come through juvenile court for a theft, a burglary, a robbery, possession or distribution of narcotics, and firearm possession. And often they were just doing what they were told by their trafficker and going down for it. And it's a really common thing to have juveniles do these things because the penalty is a lot less, and there is a little bit more focus on rehabilitation in juvenile court than there is in adult court, for example. So they would have the youth be their fall people for it. Recently, we were working with law enforcement for a case where the pimp and known victim were pulled over together, and they had multiple guns and narcotics in the back seat of the car. And in front of the cops, the pimp turned to her and said, I'm going to need you to take this one for me. And she did. She wouldn't budge, even though they said, we heard him say that and we know you did it. She just kept saying that you didn't understand, and I am the one. This is all me. He had no idea. And they're really conditioned to protect him. So there's a few cases where they are also criminalized when it's part of the fact pattern that they're being pimped and trafficked. And so it shows that it's not just complicated situations. We're sort of failing to identify in even obvious situations. Ohio has had a few high-profile cases of clemency. Elizabeth mentioned earlier Santoya Brown. There's also Alexis Martin, that she had a familial trafficking experience where a family friend was raping her and then started trafficking her. She ended up in foster care, and he pretended to be her dad to pick her up out of foster care and then started pimping her. And she shot him and killed him, and she was 15, and she was still arrested, prosecuted, criminalized. So like, in what situation is it not very obvious that it was self-defense and really difficult lived experiences, and we as a system failing her multiple times, including in that conviction. Santoya Brown, like, you can see how young they look at the time of their arrest, and we're still not really trying to dig deeper and find out the truth. She was recently granted clemency after 15 years in prison. And I really want to focus on Hope Zephyrjohn. She was so young at the time of the rape and the abuse that she was a bottom for him before she was an adult. And this is very common where family members or community members leaving the children behind and they experience so much trauma that they're hardened early and traffickers are able to really utilize them. So she talked really candidly about how she went from juvenile detention to this guy. It was just an extension of prison that she felt controlled and like this was her life. He made her recruit youth. He made her keep bringing in additional business. And when she didn't, he really brutally abused her. So she kept doing what she was told as a let's stay alive sort of mindset. And when he got prosecuted, because he was trafficking youth, she got prosecuted as a human trafficker with him and alongside him, because many of those youth said that they had been recruited by her and that she was the one that sort of managed the day-to-day operation. So if you're familiar with the term bottom or bottom girl, that's what she was. She was the bottom. She was running the show. She was the visible person so that the trafficker could have all plausible deniability and say, no, that's her. I had no idea. And we really are failing the bottoms across the whole country. Even in the jurisdictions that are really passionate about it, we're really failing. And people say, but she was recruiting minors. She was trafficking minors. Like, how can we not prosecute her? We need to stop the behavior. And so they're being criminalized in very high numbers. And that's, I think, the area where it's most worth really breaking down the cultural implications of it. And what we start, quote unquote, worthy labeling either a case or a victim. If you ignore everything that led up to those decisions, it is easy to be black and white, but that's not real life. And that's, I think, how we're failing. So it's bottoms, as I just described, but also one type of trafficking, massage parlor trafficking. We very much, as a culture, don't listen to what the victims are saying. And sometimes it's only labor trafficking, it's not sex trafficking. But if it's only labor trafficking, we just dismiss it. I see so many articles where it's just calling them a sex worker from China who didn't have access to their documentation and didn't get paid a set wage and worked 24/7 and slept on the massage bed. It's like, look, okay, but we still have labor laws in this country. Even if they signed up for certain things, we don't accept that subpar treatment of other people. So we easily dismiss what we decide is worthy and unworthy. And that's, I think, the biggest area where criminalization happens. And we arrest for felony level offenses people that we don't deem worthy considering a victim. So if we can really keep an open mind to the way trauma manifests, I think it's going to go a really long way, especially in these applications, just really being aware of trauma. And that also all applies to labor trafficking as well, that we have policy considerations that really change our motivations around things. For example, for the sex trafficking, it's the prostitution emphasis, but for labor trafficking, domestic servitude cases have a lot of diplomatic offenders, and we don't politically, first of all, always have the power to prosecute diplomats, but also it's not a political choice that we always want to make. And then for industrial labor trafficking, they all are so vital, not only to our economy, but our internal supply chains, that we don't want to disrupt that either. And it's very much at the expense of victims. So I'm just going to conclude briefly chatting about how trauma is not always how you're going to expect. And almost never are they just going to break down and start crying for you. It's really going to be tough, cold, earning trust, and not even knowing if they can trust you. And it takes a lot of rapport building. And it's worth noting that sometimes having that flat affect and not being really communicative is a form and sign of trauma that doesn't mean they're not collaborating. It means that they're expressing trauma to you. Sometimes it's even really intense or angry, and that's still also worth looking at. So maybe by the time you get these cases that you're supporting, the trauma has been minimized. I really hope that we've been able to provide that kind of support. But when you're looking back on the case you're advocating for clemency for, and if there are judgments in those case files of hostile or flat affect, or she's not really engaging, or he was not forthcoming with information. Those are things that you can notice as signs of trauma that were missed that will help you in the clemency advocacy. And if in your advocacy or rapport building with the victim, the trauma like reappears, that's also very common and normal and worth paying attention to. Okay, I think, yes, this is going to be my concluding slide. So there's also, when you assess the evidence that was maybe presented in the past to help build out what you're looking at, I have noticed quite often that until investigators and prosecutors really understand the different ways trauma can manifest, trauma presents to them as untrustworthy. And that's because sometimes there's inconsistencies. Sometimes the person that's sharing the abuse that they experienced doesn't want to be judged, or they've been judged in the past and they know what's been held against them, so they withhold until they trust you, and that's been held against them. So if you see that also in your case file, know that we can tie it back to trauma and past experience and extreme fear. And most commonly in both my domestic violence and my human trafficking cases, the number one barrier that I had to overcome with all thousands of those victims was they wanted to know that if they had the courage to stand up, that we were going to stand with them, that we weren't just expecting them to help us prove the case and then leave them to face the physical retaliation that could come from the abuser. That if we were just going to get him 6 months of probation and he was going to spend all of it like hostilely harassing them, that we would make sure that that couldn't happen. And so you'll probably see quite a bit of reticence from the lack of wraparound support that could happen. And those are also really strong pieces of advocacy you can bring now to show why it was such a logical decision for them to not come forward, or to stop cooperating in the case, or to not share a specific piece of information that you now have because they're now out of the situation and feel safe and free to share that information. So I think the biggest piece of advocacy I can bring is the fresh set of eyes that you're looking at this case from the lens of, how do I prove the abuse or potential victim status? And using that lens will be a great shift, because again, going back to the initial section of this presentation, the investigators are looking for what's the truth, right? They're not always looking for who's the perpetrator and who's the victim. Sometimes they're accepting or leaning into there might be a gray area. So our lens being a little bit different from that, since it's a different part of the process, I think really will go a long way, and has the ability, I think, for us to also retroactively educate the investigators and prosecutors in hopes that we can sort of stop repeating this pattern. So that is where I will conclude. And I'm grateful for all of your energy today.
Thank you, Rochelle. That was great. My name is Gina Lungwitz, and I direct the Domestic Violence Clinic at UT Law School. And when we started the clinic many years ago, we did only civil litigation on behalf of survivors of domestic violence initially. But one thing I became very frustrated with was the number of survivors going to prison. And so I had the opportunity, through the help of a fellow, to learn how to do the parole process. And that's how I got really involved in learning about the Texas Board of Pardons and Paroles and kind of how things work there. We started doing those parole packets about a decade ago. And what I want to say about this is this process that we're talking about today, this new clemency process for survivors of domestic violence and trafficking, is a brand new process. So there are going to be bumps along the way, and we don't have every single answer of what the Board of Pardons and Paroles is going to be looking for and that sort of thing. But in the parole process, we learn some things. We represent survivors of domestic violence who find themselves in prison due to their victimization. And so most of our clients are coming up for parole after having killed their perpetrators. So similarly, we will be requesting pardons, and we are working on our very first packet. So we haven't even completed this process yet. So I say all that to say that there are some things that we have to do as part of this process. The board has made it really clear about, and there are some things that we as advocates can be creative about. So I want to talk a little bit about that. Let me start my slideshow here. So I'm here to talk about really the nuts and bolts of putting together the packet and creating reentry plans. There are some things that the board has told us have to be included in the packet. If you are an attorney, there's a registration form that you have to fill out and include. Also, if you're an attorney and the client has been convicted and sentenced to TDCJ, they aren't on deferred adjudication or something like that, there is a fee affidavit you have to turn in. So those two things we're certain of. You also have to turn in the application, and that's something Elizabeth told you about in her slide. This is the website that you go to get all of those forms. This is their homepage, and if you look on the left-hand side of their homepage, you'll see human trafficking and domestic violence. That's a tab you can click on. That's going to give you the form for the application. The form for the attorney forms are found a few tabs up in forms. So that's where you're going to look, and that's where you're going to go, and you're going to be able to get to that. That's what the page looks like. You'll notice there are different applications depending on whether you are advocating for somebody who's currently incarcerated or somebody who has been released. So you'll want to take a look at that to make sure that you get the correct application. So back to the items that must be included. Those first three you can find on the Board of Pardons and Parole website. The next thing are 3 letters of recommendation from non-family members. And this may be tricky for some clients depending on their support system. A lot of people who find themselves in prison sometimes, especially if they've been there a long time, have, if they had a support system, have lost that support system. So sometimes you might have to beat the bushes a little bit to find people to write letters. So let's say you found somebody who's willing to write a letter. What does it have to include? This is the information that the Board of Pardons and Paroles lists that needs to be on those letters of recommendation. They should be dated. They should be an original. You should have originals. They should be addressed to the Board of Pardons and Paroles, and it specifically says, and not to the clemency section or the to whom it may concern. The person writing the letter, the board wants to know that they knew they were writing a letter to the board. It needs to recommend a full pardon. As Elizabeth talked about earlier, this is a process for a full pardon, and it needs to have the name, occupation, signature, phone number, and mailing address of the person sending it. So when you have found someone to write these letters, I would send them a list. Here are some things that must be in your letter of recommendation. Now, does that mean you can't have more than 3 letters? Absolutely not. If you can find a bunch of people to recommend it, I would suggest that you do that. But my guess is they aren't going to consider anyone who doesn't have these 3 letters of recommendation. What else has to be included? Court documents. Now, when I first read this, I thought, I'm a lawyer, and court documents, that's a pretty broad category. So what does that mean? Court documents, you'll want to have certified copies of any time your client has been arrested as an adult, even if they weren't convicted. You'll want to get certified copies of the complaint or indictment or information, the judgment, including the sentence, or the dismissal, disposition, discharge, or discharge certificate. And if restitution or a fine was put in place, you want something from the clerk showing that that has been paid. So those are going to be the court documents that you'll want to get for any time your client has been arrested. So you may think, how does she know all this? It's not that I'm a genius or anything. It is that there's this handy website, and there's a lot of good information that will just give you kind of an idea of what the Board of Pardons and Paroles is looking for. And so I would strongly recommend that you take a look at that when you start to do one of these cases. So those are the things that are required that we're all gonna have to do in order to get one of these cases started. But in doing our parole work, we have learned that there are some other things that you may, that could be really helpful if you do it. And that is, first of all, a succinct cover letter from you. You will want to request to meet with the Board of Pardons and Paroles. We've been told that they will meet with us. So you want to request that. Using bullet points or headings, you'll want to tell the most compelling parts of the survivor's story. You're also going to do kind of a more thorough job in the application, but I think having a cover letter with real succinct, like bullet point headings, and then a few sentences to go underneath it to put the offense into context. And I think that's really what we're all about. We can read on paper what our client was convicted of doing, but putting that into the context of the violent relationship is really important. And to put the reader in the shoes of that survivor. So if you like to be a storyteller, this is your chance to do some really good advocacy, telling your client's story. And when I say story, I don't mean telling a lie, telling their version of what happened is really going to be important. You want to include anything positive. The Board of Pardons and Paroles likes things like a client who has had good behavior while incarcerated or on parole, somebody who is active in rehabilitation efforts. You know, when people are incarcerated, a lot of times they take a lot of classes. They tend to be religious classes because that's what's offered a lot. So you want to get all of their certificates from that. You want to show that they are active in rehabilitation efforts and any counseling received, anything like that to show that they are doing their best to be a good and productive citizen. If your client is incarcerated, you'll also want to make a plan of re-entry. This is where you tell, you talk about how someone who is on the inside behind the walls of a prison, when they get out, how are they going to support themselves? And we'll talk a little more about that in a second. Another thing that the Board of Pardons and Paroles has told us, if your client is still incarcerated, you will need to show exceptional circumstances. And I'm not quite sure. I mean, I think all of my clients are exceptional and the circumstances are exceptional. We aren't sure exactly what that's going to mean, but that's something that you need to address and talk about what kinds of things might be exceptional. I may give you some examples. Maybe your client has taken a whole lot of courses, has all sorts of certificates, and hasn't been written up for too much discipline. Something not to be too afraid of is people, especially in my experience in women's prisons, get disciplined for everything. I was on the phone with a client this morning, and that client was talking about how she got written up for having a towel out of place. She got written up for having a fan somewhere where she wasn't supposed to have a fan. I had another client get written up for having chapstick. So if you look at their discipline record and you see a lot of discipline, I don't want that to scare you. That client who's been disciplined recently for those things just got moved up in a trustee level. So I don't think you have to be terribly concerned unless there are bigger things like assaults and stuff like that. But anyway, the other thing that I think is really important, next week we're going to talk about mitigating evidence, but your cover letter should cite to supporting exhibits if you have some. And I'm going to talk a little bit more about those supporting exhibits. The kinds of things you might want to gather, the criminal records of the abuser or the trafficker, you can include those as an exhibit. And so in your cover letter, you may want to say, you know, my client, other than this conviction, has no other criminal history compared to the history of her abuser, for example. If your client has medical records because they were injured by their abuser, then you might want to get their medical records. Maybe they have mental health records. Had a client whose offense occurred 3 days out of a mental institution. So getting those sorts of records. Maybe your client was, several of the people Rochelle talked about were in foster care. Maybe getting their child protective services records. School records. I have a client who is low IQ, getting those school records to show that. Any photos of injuries, if you have any proof of victimization, sometimes you aren't going to have that, but if you have that, you might want to gather that. And all of this, when you say, you know, in your cover letter that, let's say the opposing party has a long criminal history, see Exhibit A, and attach those behind there. The communication between the client and their abuser or trafficker, if you have any. I mean, the beautiful thing about social media now is that my job has changed dramatically in the kind of evidence, the kind of thing that people like text about or email about or put on Facebook. And so finding out if there's any kind of communication that they have saved that might indicate control and abuse. Witness statements from people who see or hear evidence of abuse. So maybe in addition to those letters of recommendation for a full pardon, maybe you also have letters from people who saw or heard evidence of that abuse or trafficking. Letters of support from friends, family, and faith leaders. Just because the Board of Pardons and Paroles requires the letters of recommendation to be from people other than friends, family, doesn't mean you can't include those letters. So if you have people on the outside, I do think the Board of Pardons and Paroles, especially if your client is still incarcerated, looks at those letters of support to just see what kind of support does this person have on the outside? Are they going to be successful on the outside? And also expert reports. We're going to talk specifically more about expert reports next week. But if there are facts in your case that are particularly hard to understand, you know, in a lot of behavior is hard to understand for people who aren't familiar with the dynamics of coercive control and violence. You may have a client whose abuser told them to you go get a knife, bring me a knife. And so they bring him the knife and that person kills somebody. And your client says, yeah, I knew they were going to kill somebody. And you're thinking, oh, these facts are terrible. Maybe having an expert talk about that. Maybe your client carried a gun and ended up shooting someone. You know, finding out the dynamics of that relationship and why was she carrying a gun? Well, she was scared. She was scared. She had been abused and she was afraid. Those sorts of things. Thinking about those exhibits and talking about those exhibits in your cover letter. I'm always concerned, and I don't know about these kinds of cases, but I know the parole board in Gatesville, I talked to somebody there one time who told me they voted on, I think, 100 cases a day. And so I worry about anything that's too lengthy and too wordy. So that's why I like to put that cover page, that cover letter on there that really, you know, boom, boom, boom. Here is why my client deserves a pardon. If your client is still incarcerated, it will be important to create a plan of reentry. And so what is a reentry plan? Well, it's a logical, viable plan on how that person is going to reenter the free world. So some things to think about. Where geographically will the survivor live? And where is their support system? Are they going to be near people who are supportive of them, who are good, solid people? Also, where does their victim, the person that they killed, or if they assaulted somebody, where does that person or their family live? Because typically you probably don't want them in the same town unless it's a really big town. If you can get them separated geographically, that might be more attractive to the Board of Pardons and Paroles. Where is their abuser or trafficker? You know, separating them by distance, I think, is a good plan. Sometimes you will have clients who have a plan of reentry that you think about, oh, I don't know that that's a good idea. I give gentle guidance in that situation, because if their goal is to get pardoned, if their goal is to get out of prison, then they might want to rethink that. And ultimately, they can end up doing what they want to, but starting a plan where they start out somewhere that is going to be something that the Board of Pardons and Paroles thinks is viable and realistic and safe. Thinking about employment, what kind of employment do they want to, you know, what kind of career do they want to have when they're released, and do they have the education for that? And if not, making something very realistic. One of the students who I think did the best job I've ever seen of a reentry plan really, you know, had a picture, included a photograph of the house the client was going to be living in with their cousin, had a little map that showed from their house that it was a walkable distance to the job that they were going to have when they got out. They were able to show that on Tuesday nights there was an AA meeting. This happened to be a client with a history of substance abuse. So addressing that, not being afraid of that issue, but showing this person is committed to going to AA meetings, and they meet on Tuesday night from 6:30 to 7:30, and she'll be off her job at 5:30 and can walk over there, you know, making something very where the person voting can really be in those shoes and think, oh, I see, that's the house, and here's how far it is. And if they don't have a car or don't have transportation, they can walk there, that sort of thing. And helping people think about transportation, support groups, counseling, especially if they have a history of substance abuse, addressing that in a reentry plan. And a lot of our clients, if they weren't religious before they went in prison, they often get religious in prison because there are a lot of religious opportunities there. So oftentimes when they get out, you know, figuring out if they attend the Methodist services, you know, what Methodist churches are nearby, just helping them find their support system. And I always think it's a good idea, if you can have it, to have a plan B. If for any reason this doesn't work out, here are some other places here's another idea for where the client could live. Not everybody's going to have a plan A and a plan B, but if there is another idea, then I usually put it in there, especially if it sounds like a good idea. So let's say now you have all your packet items, you got them all together. What do you do with those items? Well, first, I usually do a cover page, just, you know, a cover page that says request for full pardon for the applicant's name, their address, their phone number. If they're not incarcerated, their phone number and email. If they're still incarcerated, be sure to include their TDCJ number after their name. And then I think it's probably a good idea to have a table of contents where you talk, you know, you're going to have your cover letter, your application, your three letters of recommendation from non-family members, court documents, and then any other exhibits you have. If you have criminal records of the trafficker, psychological evaluation of your client, you don't have to have that, but these are just some things, you know, some of those other supporting documents that you might have. And then you're going to put them in a notebook, and we have been told to send one copy to the board. So that's what you're going to do once you get it all completed. Where do you send them? This is where you're going to send them, to the Texas Board of Pardons and Paroles, the Clemency section in Austin. And that doesn't matter where your client is located. I think almost all of my clients are in Gatesville. And so when I go advocate for them for parole, I go to Gatesville for that. But for these clemency petitions, they're going to go to Austin. So what happens next? Well, this is a new process. So we're learning some of this together. But if you don't hear from the board regarding a date to meet with them, then you will contact them to set up a time. Right now during COVID, all of our meetings are by phone, which isn't ideal. I much prefer to meet with people in person, but that's what's happening at the moment. You will decide who all will go with you. So it is rare that we take people with us. But for example, the release plan, let's say your client is incarcerated, and let's say that the person you're releasing them to, you've talked to them and they sound great. If that's true, then we might want to consider taking that person with us so that the board can see, oh, there's a real live person who this applicant is going to live with when they get out. But you want to be real careful. You don't want to take, I'm real careful. If I take someone, I can tell you right now, I've taken one person. I've already decided my first pardon, we will take someone, the person who our client would be released to, because I think she will be impressive to the Board of Pardons and Paroles. You want to prepare for an oral presentation. This isn't like you see on TV where you know, your client is there and you're there, and it's not a court setup at all. I mean, I'm assuming this will be similar to parole, and that is you're sitting at a table with somebody. It's just a conversation, and usually it's a very, very one-sided conversation. It's you talking and them taking notes and not showing their cards very much. If you are going to take others with you, be sure to prepare them so that you know what they're going to say. Everybody needs to be on the same page. You just need to have everybody, you know, if you say your client's going to go to a halfway house and they say they're going to come live with them, that's not going to make much sense to anybody. So just make sure everybody's on the same page before you get there. So then what happens next? Well, hopefully when you get the result, you're going to be celebrating. That's what we all hope that we're going to be doing. If it's not granted, the applicant has to wait at least 2 years before they reapply, if they reapply. So that's just something to know. And so you'll want to send a termination letter terminating your attorney-client relationship with them, unless you want to continue in some other and sign some other sort of contract with them. So that is, that's what I have to say about putting together a packet. You're welcome to contact me for help. My email is that lower one there. Also, Helen Gabler does parole work at the university, And she is also said to put her email on there. She is available, so feel free to do that. I was told to put on here all about CLE credit. This is for today. You'll get an hour of ethics, which is very precious to lawyers, both in Texas and California. There's the name of the training and the number. You'll want to make sure you input that with the bar. And if you are interested in signing up to help with survivors, that's the address you'll go to. And I'm happy to stick around for a minute if anybody has questions or anything like that.
Thank you, Gina. I just wanted to conclude, we've focused a lot on clients that are incarcerated because those are the most challenging cases. And so we thought if we train you on those and you get an easier case, it'll be all gravy from there on. Most of the cases that we will be referring during this first round will actually be clients who have already been released from incarceration and who are in fact home. And they'll be seeking to receive a pardon so as to remove the collateral consequences of their crime so that they can get access to the benefits that I mentioned earlier in terms of access to jobs, housing, educational benefits, etc. So I want to just sort of set that context that most of the people for our referrals during the first round will be already released. And then I want to just close by encouraging all of you to really dig deep and take it within your heart, whether you can represent survivors who have this wonderful opportunity. We are so excited about this opportunity and this program. We have a couple of other benefits that we are going to be trying to provide through the Survivors Project. And the first is the access to experts and investigators. We are currently fundraising to be able to provide individuals and experts to pro bono partners who sign up. So please know that we are working on expanding our resources there. We are also working with organizations throughout the state of Texas who will be able to help with providing employment to those who are released and other wraparound support services. LSJA has just submitted a request for one of our staff members who is herself a survivor of human trafficking to move out of an administrative assistant position and become peer support for every single survivor who goes through this program. And the Texas Criminal Justice Coalition is working with SAFE in Austin to gather a group of survivors who will be a support network for all of the applicants as they go through this process. So we are trying to think very holistically in the way that we approach this. But with that, I think we will conclude for today. If you have any questions, please reach out to us. We are thrilled by the number of people who have joined today. We reached over 100 people today who joined us on this training. I want to thank my fellow panelists who were excellent, as they always are. And we hope that you'll join us next week as we delve into some of the trauma and some of the mitigation evidence that you can collect for your clients. And it will be as stellar as this panel group was. Thank you for joining us today. Have a fantastic Friday. As you know, you've done some real good here today. Thank you all.